Welcome. My name is Shannon Bryant. I'm the Traffic Safety Resource Prosecutor for the state of Nevada. This is part of the TSRP training video series intended for Nevada law enforcement conducting DUI traffic stops. These short training videos are intended to refresh training for in-service officers who have already completed their Category 1 training. This training is on implied consent versus consent in the context of Nevada's DUI laws, and will hopefully clarify what these two terms mean, why they're important to your DUI investigation, and how to avoid potential problems in your case. So let's get started. First, what is implied consent? Implied consent is a term used in nearly every state, including Nevada. In some jurisdictions, it's called informed consent, but it is the same thing as implied consent. The implied consent law in Nevada comes from NRS 484C.160. Without restating verbatim the statutory language, this statute states that everyone driving on Nevada's roadways has, just by the act of driving, impliedly consented to an evidentiary search of his or her blood if he or she is suspected of driving under the influence. This includes misdemeanor and felony DUI offenses. Before 2013, this statute was the basis for conducting forced blood draws in Nevada when a DUI suspect refused to consent to the evidentiary search. The reality now, though, is that the implied consent law really applies only to the DMV hearings, where a driver is facing a potential revocation of his or her driver's license. DMV hearings are administrative hearings in nature and not criminal prosecutions, because there is no potential for a person's rights to be taken away. A license to drive is a privilege and may be given, regulated, and taken away by each state without any criminal proceeding. Since 2013 and the U.S. Supreme Court's decision in Missouri versus McNeely, a seizure of blood during a DUI investigation is considered a Fourth Amendment search. Warrants will be required absent some recognized exception. As I just stated, the practical effect of the U.S. Supreme Court's decision is that Nevada's implied consent law only really applies to DMV hearings. Under NRS 484C.160, the Nevada law enforcement officer is required to advise a DUI suspect of the implied consent law so that the driver understands the driver's license revocation consequences. Each agency has its own implied consent warning language that it has crafted, and you should read only what approved language has been provided to you by your agency to the DUI suspect. Do not, under any circumstances, attempt to explain or summarize the implied consent warning to the suspect. This will unintentionally create a question of whether any later obtained consent was done so through coercion, particularly with an impaired person who is in your lawful custody. If for some reason the agency's implied consent warning was not read to the arrested person, this will not affect the criminal prosecution. It will, however, most certainly affect the DMV hearing. So, now that we've discussed what implied consent is, let's briefly go over what consent means in the context of blood draws in DUI cases. As mentioned a moment ago, a DUI blood draw is a Fourth Amendment search. For Fourth Amendment searches, a judge must determine whether probable cause exists and make a finding that the search is reasonable to permit law enforcement to conduct the search. This is required for all Fourth Amendment searches and seizures. There are exceptions, however, and consent is one of those exceptions. So what consent really means is a waiver of someone's Fourth Amendment rights as guaranteed under the U.S. Constitution. That waiver of constitutional rights must be voluntary. Whether a search or seizure is voluntary requires a look at all of the circumstances surrounding the consent. The suspect's state of mind. Was he or she crying? Were they confused or upset? Were they impaired? This is particularly important to think about since impairment is the entire reason that you're wanting to get the blood draw in the first place. So far, there is no case law in Nevada to tell us how impaired is too impaired to consent. Please don't be the one to give us that case. Use your best and most cautious judgment. Mental capacity. You will have to use your powers of observation here. Does this person appear to be cognitively impaired? Slow to understand? This is a judgment call that you must make. What actions you take will also be very closely scrutinized. Your body language, your tone of voice, your words, even your appearance. If there are other officers present, that fact might contribute to a police-dominated atmosphere. In such circumstances, a defense attorney will likely argue that consent was not voluntary. In a vast majority of your DUI blood draws, the suspect will be arrested or detained. This fact is also an issue that comes up frequently because the person is not free to leave. Finally, any language barriers will also be considered. This is an issue that comes up with increasing frequency, and law enforcement personnel need to be aware that while a person might be conversant in a language enough to get by, that may not, and is likely not, enough to understand constitutional rights and then waive those rights. Be mindful of this, and where there is a doubt, politely explain to your arrestee or your suspect that you will need to ask the judge to make the decision about obtaining the blood draw. Then go ahead and apply for the warrant. Remember, the implied consent law is still valid, but it does not mean you have consent for your criminal case. It is a common myth that obtaining consent is easier than obtaining a warrant. The truth is, that's not necessarily the case. That's because, as we just covered, consensual searches are warrantless searches that are presumptively unreasonable searches, and they will be subject to considerable scrutiny to see if the consent was truly voluntary. The burden will be on the prosecution to establish this. And that means a court hearing. And that means a lot of testimony from the law enforcement officer. Your actions will be subject to considerable scrutiny here, and the defense attorney has every motivation to find those issues. As I said, consent is not necessarily an easier path in the long run. Let's recap. Implied consent comes from Nevada statute NRS 484C.160. It requires that the law enforcement officer advise a DUI suspect of the driver's license revocation consequences if he or she refuses to consent to an evidentiary test. It is required to be read to every DUI suspect. You must read only your agency's approved implied consent warning. Do not try to explain it. If for some reason it is not read, remember, it will only impact the DMV hearing, not the criminal prosecution. For consent, remember, this is a waiver of constitutional rights. Because this is so important, that waiver must be voluntary. It is the prosecution's burden to prove that the consent was voluntary, which necessarily means you, as you were the one who obtained it. In the long run, proving consent is not always easier than obtaining a warrant, because when a warrant is obtained, the burden is on the defendant to show that the judge made the wrong decision. This concludes this training video. I am Shannon Bryant, your Nevada Traffic Safety Resource Prosecutor. On behalf of the National Highway Traffic Safety Administration, Nevada's Office of Traffic Safety, and the Washoe County District Attorney's Office, thank you for all you do and for keeping Nevada's roadways safe.